everybody. This is Doug, and you are listening to What's the Hazard. It is Friday, sometime toward the end of April. Do you know what the date is by any chance, Justin?
25th.
The 25th. We just had an incredible rainstorm last night. I was watching footage on the news of the flooding down
Saddle Creek.
Saddle Creek. Do you not live on Saddle Creek?
I do not live on Saddle Creek.
Oh, my God. It was horrible, man.
Yeah.
Cars underwater.
Yeah, you never really know what's going on. And then I saw a video of a dumpster floating down
the middle of the street.
Middle of Saddle Creek. I thought, okay, well.
Incredible. But it is that time of year here in the Midwest. You know, we get rain, we get sunshine, we get snow, we get whatever. So we have to endure that for a few more weeks. I've got one announcement to make before we get started. It is time for Bike with Mike. It is an annual fundraiser hosted by the Kudelek family. It is on June 7th this year. You just mentioned to me that you're a bike rider. So
yeah.
Have you had your bike out already?
Oh, yeah. My wife and I have put on quite a few miles.
Have you?
Yeah, for this time of year.
I haven't even pumped up my tires yet. So
really?
I need to get a little bit of saddle, time before I ride this. But this is an event. It is for mental health awareness, again, hosted by Steve and Ann Kudelek. It's over at Wabash Trace, which is that kind of a little gravel trail over in Council Bluffs. Really great event. So if you're looking for something to do on Saturday the 7th, I would encourage you, go to Bike with Mike. Just Google that up and register. I think it's $40 to register, and it is a great day. We ride about 10 miles to Mineola, I think. We eat. You just kind of share some conversation. There's some music. There's activities for kids. It's become a great event. I think this is the 5th year, and they are about to pass $1 million in donations. I mean,
wow.
It is a big deal.
So you're riding to Toby Jack's, right?
Yes, we ride to Toby Jack's. That's exactly right, man.
Toby Jack's has tacos, margaritas, outdoor seating, great area to listen to bands.
It is wonderful.
On a nice day, that's the place to be.
It is. So I would encourage you. We only promote 2 events on this particular show. The 50-mile march, which is the fundraiser for veterans. Also, unfortunately, kind of focusing on mental health issues and challenges, and Bike with Mike. So if you guys are available, please join us. It's a great time.
Yeah, so. I'll put it on our little Facebook page. You got probably 300-400 cyclists on there.
That would be wonderful.
Yeah.
They might be a little bit annoyed by this group. This is not a group of cyclists necessarily, so there are some challenges to this ride, as we just talked about.
Yeah, what will probably happen is they will ride the 10 miles to Toby Jack's, and then they will just continue for another 30.
Yeah, how long is that trail, that Wabash Trail?
Oh, that'll go. I think you can do almost 100 miles out and back. So I believe it's 47 or something.
Like that. Yeah, amazing.
Yeah, it goes all the way south.
Yeah, it's really cool.
Yeah.
It's a nice ride. So keep that in mind if your schedule permits. This is Justin High. He's an attorney here in town. He is, should I call you partner, principal of
Partner's
High
fine.
Younes?
Yeah.
Partner. You're probably the man, though, right? Or are you guys equal partners?
Oh, no, we're equal partners.
Equal partners.
Yeah,
okay.
we just, do different things.
Do different things. And we had the occasion to meet recently. Well, we've actually met a couple times. You officiated a wedding for a friend of ours, Mark McClure, that I had forgotten completely because I might have had a drink or two at the wedding, but it was over in Des Moines at the ballpark.
That's right.
You officiated that, and then coincidentally, we had the occasion to work on one of your cases. I was asked to just write an opinion on that, and I have to tell you, man, I was not enthused. I have done that a few times in the past, and as you were going to describe for us, this whole legal world is really confusing to me.
Well, we can simplify it.
Yes, you do. For me, it's very daunting and overwhelming. But
yes.
we met prior to a scheduled trial, and we sat down, and you were just kind of prompting me a little bit. We were talking about what my testimony might look like, and you were so passionate about this, man. You were so intent and committed to getting this wrong resolved in favor of. Is it a plaintiff?
Yeah.
You were representing the plaintiff,
yeah,
an injured party.
Injured worker, yep.
And I was just blown away, man. So just to your credit, I was totally on board. When I walked out of there, I was actually looking forward to testifying. And I had, and I don't normally feel that way. And it did settle in favor of the plaintiff, which was fantastic. So I didn't have to testify.
Right.
Which is also nice. But I got to credit you, man. I was really inspired.
Well, thank you.
By your commitment.
Well, yeah. I mean, I appreciate that. And I guess...
Where does that come from?
My client. That's it. It comes from my client. I represent injured people, injured workers, victims of negligence. And, you know, we don't take the kind of case that isn't really, I guess, I don't want to say merit. I don't want to say it doesn't have merit. I want to say I take the kind of case where there is something seriously wrong, and I'm going to fix it. Mm-hmm. Somebody's being treated in such a way that is just not acceptable to me. And it's really two things. It's that situation, and then I meet the client. I spend a lot of time with my clients. A lot of people don't do that. Mm-hmm. I go to their houses. We have lunch together. I have clients where I have a weekly phone call where, unless I am sick or dead, I'm making this phone call. We might not talk about their case. We might just talk about them and how their week was. But I develop a relationship with these people. So that's where that comes from. Mm-hmm. Because when you really understand the story, when you really understand what's going on with your client and you like them and you want to help them and you see this big wrong thing that you're going to be able to fix, that's where the passion comes from. It's not me. It's their situation. Yeah, we are not, and we're not a volume shop. Like, I don't have any billboards. I'm not going to have any billboards. That's not a thing I'm ever going to do.
Yeah.
Yeah, we're more low volume specific things for a particular type of cases.
Yeah. So High Younes is 69th and Dodge. If you're an Omaha person, are you an Omaha guy? Are you from Omaha originally? Or
No, originally. So when people ask me where I'm from, I say, you know where Kearney is? So
I know where this is going.
Yeah, so then you might know where Holdridge is, so then you might know where Bertrand is. So I'm from Bertrand, Nebraska.
Okay.
Population 608. Okay. So if you passing through Kearney, keep going another half hour and then head south about 10 miles and you'll find it.
Yeah.
And so my law partner's from Kearney.
Okay.
So we're both from out west.
And are you both Creighton law guys? Mm-hmm. So you went to Creighton Law School?
I did.
Which is a very nice law school.
I loved it.
Did you go to Creighton University then as well? Or?
I did.
Excellent. What was your undergraduate interest?
My undergraduate interest, well, there wasn't one. There was a lot of them.
Okay.
But psychology and English, that's the degrees that I got. And I always kind of knew I was going to go to law school.
Is that the family profession? Or
Kind of. So on my mother's side, she has 8 brothers and sisters. So there's, and one of my uncles was a lawyer, and then another one of my uncles is a lawyer. It's sort of, my cousin's a lawyer, it's there. But really, my personality, I knew I was going to be a lawyer since the 2nd grade. When Mrs. Wendell, the teacher, stopped class and said, "You, son, you're going to end up being a lawyer." Because just the way that I would ask questions, and I would I would question everything. But yeah,
you were litigating even in 2nd grade.
I guess that's the way to put it.
To some degree.
Yeah.
That's awesome, man.
Yeah.
Very cool. And so I'm going to go through this list of the areas of practice, HY attorneys, if you're looking on the website, on the internet, HY attorneys. Accidents, work comp, labor and employment, personal injury, wrongful death, product liability. I thought that was interesting. Dangerous drugs. Are you going to be litigating like Ozempic and some of these?
We might.
These drugs at some point? Is that?
Yeah, we might. So that's what you call a mass tort.
Okay.
And my law partner and I have looked at this sort of, I don't want to call it an industry. It's not an industry. We've looked at this particular type of situation with take the opioids. Mm-hmm. Those people knew exactly what they were doing.
Yeah.
They were creating basically legal heroin and then putting it out there because they knew people would get hooked on it. That's a wrong that we can right. Mm-hmm. And so that's why we're interested in that. Those are very complicated, huge
I can't
cases.
imagine.
Yeah, but we can talk about that and
Very
how they
interesting.
work.
I just find it interesting. You have a soft spot for the underdog. I mean, you are intent on righting wrongs. It looks like to me on the stuff that your guys are handling.
Yeah, it's kind of I don't like people getting away with stuff. I don't like bullies. And yeah, that's pretty much it. I mean, one of the great things about my job is I get to sort of take a situation where the little guy is in a bad spot and level the playing field.
I like that.
Yeah.
So can you explain? So there's so much of this I don't understand, but I have a son that is applying to law school. So.
Really? Where's he going to go?
Well, he's applying to Creighton. He's at the University of Iowa right now, so he's going to apply to Iowa, Creighton, maybe Nebraska probably. He's a Midwest kid and would probably like to stay in this area.
You know what's funny? Iowa, Nebraska, Creighton, you really can't go wrong. Those are 3 really good law schools.
Yeah, that would be wonderful. He could get in any of those 3, so we'll see. But that being said, one of the things I don't understand, as an OSHA person, we were always around work comp, but they are not the same programs, obviously. How is work comp different than like a personal injury or catastrophic injury case? I thought work comp was the only remedy that you had in a workplace.
Well, see, and most people think that, but it's actually not quite true.
Okay.
So work comp is a separate and distinct system. I might be wrong on my dates, but I think it was around 1910 when in the United States we created this system. It took about 10 years, and then every state had it. Almost every state had it. So what you're doing is you're saying, okay, if there was an injury at work, the injured worker doesn't have to prove fault. All they have to prove is that they were injured at work.
Okay.
Now, why is that good? Because a lot of the time around 1910, you'd have workers, they couldn't possibly compete with their employers. Or their employers were, this started in New York. You'd have a ship that would come into that's why it's called the Longshoremen's Act. You'd have a ship that'd come into the harbor, and a bunch of longshoremen would go and unload this thing, right? Well, that's dangerous work. One of them would get catastrophically injured. Well, guess what? The ship sails away. There's really no recourse there. You're not going to be able to pursue that company. And so we created this sort of, I don't want to call it a social safety net because it's not, but we created this separate system where you could hold employers accountable for the injuries that their workers received in their service. Like that's the theory.
Okay.
So we call this the grand bargain. So the workers don't have to prove fault, but their damages are capped. They're limited. There's no damage for pain and suffering. There's no damage for loss of enjoyment of life. There's no loss of consortium or anything like that. So if you get hurt at work, it's theoretically easier to take care of yourself and your family with loss of income, medical benefits, but you don't get any of the other stuff. Now, and most people think, well, if you're hurt at work, that's your sole remedy. That is not true.
Okay.
Yeah, if there is somebody that is separated from your employer, and they're the ones that actually committed a tort, well, now you actually have 2 cases. And so I don't know how many times I've had a consult or, somebody comes to me for a second opinion and something's going on with their one case, and I'm like, well, you realize you have 2 cases, and they have no idea.
Yeah.
Yeah, it happens kind of a lot.
I didn't. And so who then is the defendant in? Is it the employer? I mean, are you able then to pursue that additional remedy from the employer, or is it like a third party? Or?
It's a third party. So, put the work comp case over here. You have the injured worker against their employer in workers' compensation court. It's a bench trial always. The rules of evidence are, I want to say relaxed is the way we...
So a bench trial means non-jury.
Right, yeah.
Sorry, man.
No, that's okay. No, I'm glad you asked that question. So it's a very, very sophisticated judge. We only have 6 judges that do work comp cases. They do them all day long. They do nothing but that. They are all incredibly intelligent and very sophisticated when it comes to deciding these cases. They know exactly what they're looking for. And on the other side, you've got a third-party case against whoever caused the crash. Yeah, the quintessential example is somebody like you. I mean, you're on the road a lot for work. So you're in the service of your employer. Well, if you're out on the interstate and a truck runs you off the road and you get injured, it's the truck's fault. So you're still at work and you get injured, so you got a comp case, but you're also catastrophically injured because of somebody else's negligence, so you have a third-party case too.
I got you. Interesting. Yeah. And that was the case that we were involved in. There was a third party, not directly the employer of the individual. So
correct.
Okay. And so are you doing both at once? I mean, if they come to you, for example, you would be handling both of those at one time.
Yeah.
And I guess that's best, that you know them intimately. So
right. Exactly. So I usually do the comp case first, usually. Like, there are a lot of factors that go into that decision, but we usually take care of the comp case first and then turn our attention to the negligence case, the third-party case. But, I mean, sometimes that changes. It all depends. But you're still dealing with the same injury. It's just a different measure of damages.
Okay.
And
so the other stuff that you were talking about, the pain and suffering things, can be addressed in that second part of this.
Yep, 100%.
Because that's really... I mean, otherwise they're just getting like a percentage of their income or something, or it's kind of a small number typically.
Yeah. I mean, comparatively, like, and it just depends. You know, I've got clients that have comp cases, and what people may perceive to be a small injury takes a lot from them. You know, I had a client, and he's a guitar player, loves playing the guitar. If he could make a living playing the guitar, it's probably what he'd do. But he couldn't. He's working in a factory. Well, he got the tips of his fingers severed. So guess what? The reason for him to live playing the guitar, he can do it, but it's just not the same. You know what I mean? He's just not as good, and he knows it, and it really bothered him. And because it was a comp case, he couldn't get a thing. That's it. That's the way it works. But, hopefully, you know, we can address those human losses in a third-party case. That's kind of what those things are all about, in my opinion.
Yeah, man. Oh, that's interesting. So the process itself, when I first asked if you would join me to do this, you kind of lit up like, oh, there's a lot of things that people probably are unaware of that we could talk about. What about work comp? Or I guess one thing is people aren't typically aware of this second option, or they don't think they have that option. But what is it about the process that would surprise people? I mean, and talk about a little bit about things like depositions and stuff that are so terrifying to most people.
Yeah, I'll give you some things that I commonly hear from clients. The first thing that I commonly hear from clients is, well, this wasn't my fault. It was their fault, so they should be paying me now, right? And the answer is no. They actually don't have to pay you now unless there's no reasonable controversy at all. Now, a reasonable controversy, that's a loaded term. That's a term of art that we use. And that is any issue of fact or law that could prevent recovery. So let's say you're in your truck and you're driving and you got an appointment on a Kearney and you stop to get gas or something and you're injured. Well, your employer can say, actually, we think Doug was doing a personal errand.
Okay.
And that's why he was hurt, and so we're not going to cover it. And so that's one of the biggest things that my clients are very surprised about, is that in a comp case, any issue of fact, they can just prevent you from getting any recovery at all. So you have no income, no medical, you're basically just floating out there. That's terrible.
Could that be a permanent situation? I mean, is that?
Well, no, that's why you hire a lawyer.
Yeah.
I mean, and I should be clear, like, I don't take cases where I can't do something for somebody.
Yeah.
You know, my office is very, very strict and specific about that. Unless we can see that there's something wrong that we can make right, a lot of times people come in and they just have questions. And I look at their case and I'm like, wow, it looks like the insurance company's doing what they're supposed to do. And you don't need a lawyer. So we turn them away. So, any issue of fact means that insurance company can not pay you, and then you got to wait. You got to hire a lawyer, file a lawsuit, get a trial date, do all the stuff. It's
so that the compensation may not be coming, or it might take a long time to be coming. And
yes,
wow,
Right.
So I got hurt, and my check starts coming next week is not typical.
Not always. Sometimes, I mean, it's not typical. No, that does happen. That's the default. Like, that's what's supposed to happen. But more and more and more, we see it not going that way.
Okay.
Because remember, another thing, I've got clients, injured workers, individual people, human beings. Hopefully, they've never been involved in a lawsuit before. That'd be great. And on the other side, it's not the employer that's controlling everything. It's the insurance company. And guess what? They do this every single day, over and over again, thousands of times, tens of thousands or 100,000 times a year. They know exactly what they're doing. For them, this is a math problem. So, yeah, two very different competing interests, like the insurance company. And I don't care who hears this. I'll stand by everything I say. They don't care about anything but money. That's it. That is their main motivating factor, is get this claim resolved for as cheap as possible. And they just apply like systems to claims.
Okay. They have an algorithm that if this, then this, and this is what we do. And
yep.
Interesting.
Yeah. And the reason I know that is because I used to do that work. I did it for 10 years.
Really?
Yeah.
Interesting.
Mm-hmm.
But man, what an advantage for you to have had that side of the experience.
Yeah. No,
interesting.
That's
is it
true.
like? I mean, that makes me think of that Grisham, the movie Rainmaker or whatever it was, where that kid dies of leukemia.
Yeah.
Is it? And the insurance company comes in with 40 guys in suits and.
Yep. Yeah.
Interesting.
Yeah, you weren't there at the last, because we started that trial. I mean, we ended up settling that case, I think, the day before you were going to testify,
you guys were seating a jury on Monday, and then we were going to start testifying on Tuesday.
Oh, we seated a jury.
Did you?
Yeah, and I remember looking in the courtroom and looking back on our side, and there's, one of my associates, my paralegal, another guy that I work with, and then one of my friends was there to watch, a lawyer. And on the other side, I counted them, 19 people wearing suits, none of whom I had ever met before. I'm wondering, what the hell's going on here? So, yeah, it's not unlike that.
Yeah. Representing the big company, the deep pocket company that, yeah. But I get the impression that you kind of enjoy that.
Oh, absolutely. They see.
It seems to me like that does not intimidate you.
Oh, no, not even. I prefer that.
Yeah.
Because, your opponents, like, this is a full contact sport for me and for everybody at my firm. This is a full contact sport. And so whatever happens, happens. I prefer they not really see us coming. Mm-hmm. I prefer that I just prepare.
They underestimate you?
Oh, yeah. Yeah, that's exactly. And it happens a lot, because I think a lot of people that do what I do and do what we do, they have a certain way of doing things. They assume every case is going to settle. Well, that's a very dangerous assumption to make. Mm-hmm. Let's talk about that for a second. I mean, people come into my office, and they were kind of like you. I mean, you were not wild about the prospect of standing in front of a jury and testifying.
I didn't realize it was going to be a jury trial when we first started. I just assumed it would be a deposition or something, and it would be over. And when you said, okay, we're seating the jury, I was like, holy shit, really? I got to, kind of intimidated me, truthfully.
Yeah, no, it can be. But most of the clients, they assume that every case settles. And so I tell them right from the beginning, like, I am preparing as if we're going to trial. And this is another thing people don't realize. It's their choice to settle or not. That is always the client's choice, 100% every single time. But most lawyers don't tell them that. So I say, I'm going to prepare like we're going to go to trial. And if at any point you want to settle this case, that's your call. Like, how the case is pled, what we do, what depositions we take, all that, that's my choice. Mm-hmm. But whether or not you go to trial and whether or not you settle this case, that's your choice. And trust me, I've had cases where I've begged my clients not to take the money because I can go to trial and get them more, and they make their own decisions,
So the defendant is typically going to make some offer. If you go to them and say he really wants out, you probably wouldn't phrase it like that, but they'll make some offer, and some people will just take that.
The very typical course of conduct in today, in April 2025, the climate that we're in is person has a case, they're injured or something happens to them or a loved one. They file a lawsuit, discovery, depositions, expert disclosures, all this stuff. And then at some point, either the court is going to force you or the defendant is going to invite you to go to a mediation. And this used to be great. I mean, when I started doing this work, mediations were wonderful. I loved mediation because it was an opportunity to sit down and explain the strengths of your case and hear about the weaknesses of your case with a very experienced mediator. We have really good mediators here in Nebraska. We're very lucky. And everybody was usually pretty reasonable. Like the insurance companies would see weakness and they would say, okay, yeah, that used to be the way it went. And then we only tried cases that were really very worthy of a trial. There's some big, huge issue of fact or something like that. That is absolutely not the way it happens anymore. Now, insurance companies view mediation as an opportunity to put a little bit of money in front of a plaintiff who hasn't been able to work for a year. Yeah. They see the balance of their checking account and they're freaking out, and versus the prospect of a really scary trial. Mm-hmm. And so they just try to they try to figure out what's the least amount of money I can put in front of this person that's going to make them jump. Mm-hmm. It's an opportunity for them to kind of speak through the mediator and get around the lawyer, mm-hmm. who's me, and see what the person's going to want to take. And I know my clients. I have a relationship with my clients. We know what we're in. We know what we're after. We know what we want. That doesn't bother me. It doesn't work on me anymore. But I know it works on some other people. Mm-hmm. Like I hear it all the time.
Absolutely.
Yeah. So, mediation is not mediation anymore. Mediation is sort of like an invitation to see the smallest amount of money they can put in front of you. And then we go to trial. And in the preparation for trial, that's when the real negotiation happens.
Okay.
So it's after everybody's cards are on the table and we're about ready to have the fight, that's when they'll actually start to negotiate. That has been my experience.
Okay. And so obviously the defense counsel is looking at the quality of your case, what you have provided through discovery and some of the other, and I'm using terms that I don't really understand very well, sure. but they're looking at that and they're gauging, this is pretty solid, and obviously they're advising their whoever their client is about better offer. I mean, it's really interesting.
Yeah, the best analogy that I can come up with, and I hate this analogy, but gambling. I mean, this is Texas Hold'em. Mm-hmm. We get closer to trial, the more you learn about what your opponent has. And what's going to end up happening. And the more you know and you get more information and more information. And, that's the way it works.
So what happened for this particular case, what happened on Monday that led to that settlement offer? I mean, was there something? Could you see it on their faces when you're sitting there and you guys are you're seating a jury, you're kind of doing these initial statements probably and stuff? I mean, what turned it, do you think?
Well, so, I mean, I don't really know, but my guess is they looked at the jury. They looked at our team. They looked at our witnesses, including you. They looked at all the stuff that we were about to do, and they realized, okay, we need to end this. That's my guess. That's my assumption. Mm-hmm. And I can't talk about this anymore without talking about Joey Lowe, who tried that case with me. Just phenomenal trial lawyer. Marine.
See the guy that I met?
Yeah.
Yeah, he was a cool guy.
Oh, he's great. Yeah, fearless, just wonderful trial partner. I can't say enough about that guy. And then all you guys, all your witnesses, all those people. I mean, Dr. Stens was fantastic. Mm-hmm. Everybody, Bruce, we were ready to go, and they finally saw it. And, it is a confidential settlement amount, but the clause the clause says essentially as long as you don't disclose the insurance company or the parties, which we're not going to do. Yeah, so that's why they paid $22 million.
Okay.
That's it.
Wow.
Yeah, because they saw the risk, and they knew that a jury could come back with a lot more than that.
Yeah, the jury, I mean, are there limits to what the jury is able to award? I mean, is that, I would assume the judge gives them some guidance on that, or no? How does that work?
So, great question, and I'm going to try and give you the best answer.
Okay.
Are there limits to what the jury can award? Yes, but not really. So a jury can do whatever they want. They have the power. They have the authority. Okay? They really are standing in the shoes of the judge, and whatever they decide is absolutely fine, unless the verdict, quote unquote, shocks the conscience or has no basis in fact.
Okay.
Like if you can look at the verdict and objectively say, wait a second, either somebody made a huge mistake or that's just bonkers, that's insane. No, then the verdict stands. That's it. So, we had a case, I can talk all about this one because we tried it to a jury, and the insurance company's best offer before trial, I want to say it was $32,000, which was just stupid. And they told us all the reasons why we're going to lose and the jury's going to hate your client and blah, blah, blah. Well, the verdict was $960,000. So they were wrong. They usually are, and then I tried, that was in December, and then I tried another one in February, and the last best offer was, I don't even remember, like 20 or 30,000, and the verdict was 200, which wasn't anything to write home about, but it was a fun case.
But a significant difference.
Yeah. I mean, anytime you beat the insurance company's offer, you won.
Yeah.
You know what I mean?
Absolutely.
Yeah. So.
And how, I'm curious, and again, just ignorant, but my understanding is your fee is based on success, is it not? I mean, it's a risk you are taking, which is why you have to be so careful about the cases you are.
Yeah. 100%. It's called a contingency fee.
Okay.
And so there are really three kinds of fees. There's an hourly fee where I work for an hour and somebody pays me my hourly rate. I never do that. Then there's a flat fee, which is I'm going to handle this case for you. Give me X number of dollars.
Okay.
And then there's a contingency fee, which is and I always explain it to my clients like this, like you will never write me a check ever. From your money to me, that never happens. What happens is we invest all the time, we invest all the costs, meaning expert fees, depositions, transcripts, all this stuff. And then if we have a recovery, we take a portion of the recovery and our costs back.
So there is no money out of pocket on the part of that.
No.
The plaintiff, that client.
No, but it's a big number. I mean, it's a third. That's the standard agreement is 1/3. That's a lot of money. So that's why we only take cases where we know we can put our client in a better position than they are in if everything stays the same.
Right.
So I always explain it to them, like, if I can't add 50% to whatever it is you're already going to get, then you don't need me.
Right.
So
interesting. But I mean, that being said, it's a big number, but you've got staff to pay, lights to pay for, a building to pay for. It's not like you're walking out of there with a third in your pocket.
Yeah, no, that's definitely not true. Don't forget the IRS.
The IRS, of course. That's true of my world, too. As a consultant, I have an hourly rate, and people are like, what? And then I'm like, you know how much of that I actually get at the end of the day after I've paid for all this other stuff?
Right.
So it is, but as we are working, I mean, I'm sending you invoices. You're paying me. Obviously, this is coming out of your pocket until there is a settlement. So there is obviously risk to this.
Sure.
You've gotten much better at it, obviously. I mean, as far as how long did it take until you felt confident in the courtroom?
Well,
I mean, because as far as attorneys go in my world, or at least in my mind, there are litigators, and then there's all these other attorneys that are sitting in cubicles somewhere cranking out shit.
Yeah, so we usually, like when we talk about, we're talking about the same thing, but we're using different words. Litigators, in my mind, is everybody that does everything up to picking the jury. And then trial lawyers are the ones that do everything in the courtroom.
Okay.
Some of us do both. I do both.
Yeah.
Some of us only do trial work. Some of us only do litigation.
Okay. I did not know that.
Yeah. And to tell you, how did I get confident? Well, I was very lucky. I mean, I've had a lot of, I guess, lucky breaks in my life and in this profession. One of them was working for Sidoro Daly and Sidoro right out of law school. Because that firm was different. The usual thing is you're a baby lawyer, you get your bar card. They don't let you do anything. Like you don't take a deposition, you don't attend a hearing, or you don't do a trial for at least 4, 5, 6 years. I tried my very first case by myself 2 weeks after I started there. And it was terrifying.
Oh, I'll bet.
And it was a total mess. And the judge was a guy named Mike Cavill. He retired, and he was very kind and very patient. And I remember he called the case, and I immediately stood up and just started arguing. And he said, maybe we should wait for a minute until the court reporter can start writing this down,
Right.
Just pure basic stuff that I had no idea.
Yeah.
Because they don't teach you that in law school.
No, of course.
Yeah, and so I ended up losing, but it was a comp case, and the verdict was $1.67. And remember, I told you these judges, they're incredibly precise, and so Judge Cavill decided, well, the injury wasn't work-related, but the trip to the emergency room to figure out if it was work-related, that was compensable, so you get mileage. So, anyway, I remember going through that experience and thinking to myself, I don't ever want to be that scared again, ever, about doing this. So I just started to absorb everything. I read all the rules. I read all the cases. It was just so I wouldn't feel that ever again. Mm-hmm. Well, you still feel it up until the point where I probably was like 5 or 6 years in before I thought to myself, oh, okay, you kind of have an idea what you're doing.
You can do this. Yeah. That's really interesting.
It was fun.
It seems terrifying to me.
Oh, yeah, it is. But I had, Al Potts, Ron Frank, I had all these older lawyers around.
Mentoring?
I wouldn't call it mentoring. I wish it was, but Al Potts mentored me for sure. But, these other guys, I would just go and ask them questions, and, they would give me the best answers they could. And then I would be free to go try it and fail or try it and win, And that's one thing about this job I really like. It's a win or lose thing. You have the opportunity to win, but you also have the opportunity to lose and learn in losing. Glad that doesn't happen so very often. That's the way it goes. So I was very lucky because by the time I was a fifth-year lawyer, I had tried probably, I want to say, at least 40 cases.
Amazing, yeah.
Yeah, and most of my contemporaries, they hadn't even been in a courtroom yet.
No kidding.
Yeah.
So I found the whole litigator versus trial attorney, I did not know that. I watch Suits. I've seen guys in is it like that?
Oh, so that's so funny.
You wear a suit, I always assume.
Yeah, I love this discussion. I have this discussion with a lot of people.
I'm sorry, man.
No, it's great because there are parts of Suits that are very accurate. Mm-hmm. And one of my stepdaughters loves that show, and we were talking about this. What's accurate is you can have a case, and at 10 a.m. there will be a development, and all of a sudden your case turns to trash. And then something else happens at 2 p.m., and now your case is great again.
You're back on the rails.
And then something happens at 4, and that's absolutely true in my experience, my opinion. Things change all the time, and they change the merits of the case, and you got to figure it out and make it work. What's not true is you don't have something happen on a Monday and have a trial on Friday. Like that's
that's not how it works.
Yeah.
It tends to move more slowly than that, obviously.
Oh, yeah. Yeah. For sure.
Isn't that frustrating? And I don't know how you keep track of that, man. Are you managing more than one client at a time?
Oh, yeah.
this is one of the frustrations that I found as an outsider. I would get called in January, and we would have a discussion, and I'd maybe put some notes or give an opinion on something from an OSHA perspective. And then I wouldn't hear anything for 9 months, and then I'd get a call where, you're being deposed, next week. Okay, what the fuck are we talking about? I don't even, I've got some notes somewhere, I think, but I found that really challenging.
Yeah, I hate that. It's not really fair to the expert witness that you've hired and asked to do a job for you. So I do something different. And we actually didn't do this in this case because you were a rebuttal expert, but what I like to do, anybody can take a deposition at any time. You can depose anybody you want within the bounds of the rules. And so what I like to do is have my expert write a report, get that all tidied up and make it so it's good and that everything that they say they can stand behind. I disclose it to the other side, and then I depose my own expert immediately, like within a couple of weeks. That way everything's fresh, and I'm the one asking them questions. I'm not intentionally trying to trip them up, which is what the defense lawyers do, the opposing lawyers do. And we have, this very concise, immediate, there's no lag time. You haven't filled your brain with 50 other things. And then, that's the way I do it. It costs a lot more money, but I don't give a shit. I mean, it produces a much better product, in my opinion.
It is interesting to read depositions. It's not exciting, don't get me wrong, but to read other people's depositions, typically when the other counsel is leading that deposition, and just watching the thought process, I found really interesting. Watching how the questions are laid out to get to certain things. I mean, there is a real art to that, that get them to contradict themselves or to walk themselves into a corner perhaps or whatever.
Yeah, and everybody's like, there are a lot of different ways to do it. I do cases with lawyers, and their whole idea, let's just intimidate the witness. Well, some people that works. And then there's other lawyers, and their idea is to ask the same question 4 different times and see if you get a different answer. And if you do, well, then you got, there's a whole bunch of different tactics. But, depositions are about facts. That's what people need to realize. It's not about tripping somebody up, in my opinion. Like, if you're a witness and I can trip you up, you probably weren't going to be called to trial anyway.
Right.
Yeah, it's in my opinion, it's mostly about what is this person going to add to the trial, and how can I use that to my client's advantage and benefit. And if you come into it like that, not let me destroy this thing, because that's what the person's expecting you to do.
Right, no doubt.
Yeah, you've been deposed before. I mean, did you think you were going to go and have a nice, gentle conversation?
No,
of course not. Yeah, so when you come in and you're not doing that, like, I'm not there to destroy anybody or beat somebody up or try to get them to, or confuse them or try to get them to contradict themselves. I'm trying to figure out what they know and what pieces of that can actually help me, if any. And that's the way I approach it, but everybody's got a different style.
Can I refuse to be deposed?
No.
If you call me, or
not if you're within the subpoena power of the court and the rules.
And that's my next. What is a subpoena? I mean, I know there are subpoenas. Like in the OSHA world, we had subpoenas for, I won't call it testimony, it's more of an interview. We could subpoena people to be interviewed and for documents. Ducis tucum and something. Forgive me. My son's a Latin major. I screwed that up. But what is a subpoena?
Okay, so first of all, there's no such thing as a subpoena, this broad thing, okay? There are different types of subpoenas.
Okay.
So let's just break them down into that, because if you're talking about one, you're not talking about the other. So a subpoena for a deposition, like what you're talking about, if a party has filed a case in a particular jurisdiction, let's just use Nebraska, so I can subpoena somebody for a deposition as long as they are within the state of Nebraska. I mean, if you're in Iowa, I can't get you that way. If you're in Scottsbluff, I still can.
Okay.
And the ability to compel them to sit for a deposition is pretty simple. I give you an invitation, the subpoena, it says show up. If you don't show up, well, I'm going to go to the court and say, hey, Doug didn't show up, and they're going to send a marshal out to find you and make you show up. Or they're going The judges have the discretion to do kind of whatever they want with that, with contempt. So,
but they don't like to be contempted. The judges, they don't seem to like that.
Yeah. Well, maybe. I mean, some of them, they look at it as just a function of their job.
Okay.
I mean, you have to.
They're not offended.
No. Oh, good Lord, no.
This is just business.
Right. Yeah, it's just business. I mean, I've been in a hearing before where the judge says, "So where do I send the marshals?"
Right.
Yeah.
Right. Just as a matter of fact.
Right. Yeah, absolutely. They get it. They understand what their job is. So, like a subpoena for a deposition. Now, if you're in another state, I can do what's called, I can domesticate the subpoena, which basically means I just file it in the other state. I open a thing in the other state, and then I use their power. So I think the question you're really asking is, how do these work? Mm-hmm. The court gives you power as a party to make people sit down and answer questions.
Okay.
That's it.
Is there any burden that you, like you said, I mean, that you are likely to be knowledgeable about this case? I mean, do you have to demonstrate that this person is important in order to subpoena them, or?
Yes, but
there's a pretty light.
Oh, yeah.
Okay.
So at that stage, when you're doing depositions, the burden is you have to show that they might have some information, which will lead you to the discovery of relevant information. So, yeah, that's a very, very low burden. And I can't even think of an instance where a judge quashed a subpoena because the person probably didn't know anything.
Okay.
So, yeah, and usually when you're talking about depositions, I mean, it's expensive. You got to hire a court reporter, and we do a videographer and all that stuff. So I'm going to spend at least $2,000 talking to somebody. Mm-hmm. So I would like to think that they got something to say, you know.
Right.
Yeah. So I can't think of an instance where a judge has quashed a subpoena because the person had no knowledge or very, very little knowledge.
And other types of subpoenas, you said you can subpoena documents, you can subpoena...
Yeah, there's a Rule 34A subpoena, which is, 34A is just one of the discovery rules. And basically I can take a piece of paper, write down what I want you to produce, give you a copy of the rule, send it to you, and then the other party has 10 days to object. And if they don't object, well, you're going to have to produce all that stuff. So I give them notice of the subpoena, and after 10 days, if they don't say anything, it's going out. And then you got to respond to me with whatever.
Okay.
So unless there's, unless there's some other issue, like it's privileged or you don't have it or whatever else.
Okay. What about, this may be a little bit off track, but I am being asked not to destroy emails or something for some reason. Is that a subpoena? I'm just thinking about like all that's going on in the government right now with the feds,
Yeah. So no, that's actually,
what is that?
Okay. So the word is spoliation.
Okay.
It is not spoilation. And trust me, I see lawyers and judges, I see lawyers mess that up. Yeah. I've seen judges mess it up. So, there's a case here. The case in Nebraska is called Norquay versus UP. It's Norquay. And essentially what it says is, if I ask you to preserve information, if you have something, and I tell you litigation is imminent, I'm about to sue you, and I don't want you to destroy this stuff, here's notice that you're obligated to keep it, then you're obligated to preserve it in some way that it is discoverable. And if you don't, well, the court can, at its discretion, give what's called an adverse inference, which is they had it, they knew it was important, they destroyed it. We don't know what it said, but you can infer that it was probably something pretty bad. Mm-hmm. And that's the way it works. So,
interesting.
Yeah, and as an expert, so you can think about that in terms of if you're a consultant or something, or a worker, or whoever's doing what, that's why they have to do that. Now, as an expert, we have to produce your file, and we have to produce it to the other side so they can make sure that there's not something really, really important that you're missing, because it might have changed your opinion. It might have completely changed the way that you look at something. And if that's the case, then they need to know, because they get to attack you all day long.
Yeah. So. Interesting. So this is not about me, but I did have one occasion where I was asked to come down and testify in front of this was in Texas, So there was an arbitrator. I think he had been a retired judge who was now this hired arbitrator. And this was an instance where an employee had been injured at work, burned by some chemicals. And, you know, he was a Latino gentleman, probably a communication challenge. The defendant was Walmart.
Mm-hmm.
And so when I show up, it's the injured party and the attorney. And just like you described, Walmart had like layers of, it looked like an orchestra. They were just kind of seated up, you know, like 14 people. And so after I did my testimony, and I will say though that the Walmart guys like beat the crap out of me. It was a really unpleasant experience. Afterwards, everybody was really nice and, hey, good job up there, buddy, you know, and all this kind of stuff. Gives me his card. Like I might, you know, I just like, what just happened? I feel violated, you know. It was horrible.
Yeah.
But, you know, and they settled. Well, I guess, I don't know if that's what they do afterwards, but there was some settlement arrived at.
Mm-hmm.
But it was totally I think that might have turned me off to the whole thing, but it was rough, man.
Yeah, so your observation is like, why is it that when we're on the record and we're doing the thing, everybody's so mean, and afterwards everybody's like, yeah, that's, I mean, like I said,
real?
This is
that the thing?
100%. Yeah, this is a full contact sport. I mean, so you see that kind of a lot. I generally stay out of all of that. And the reason I do, it doesn't make any sense. Like, I don't need to burn the bridge on the way out of town. I don't need to do anything. I'm just going to go in and make my point. And I don't ever really, well, not never, but I don't get aggressive with witnesses unless they are really, really out of bounds, and I need to. It doesn't make a lot of sense. I don't find it persuasive. I don't find it persuasive to jurors or to judges when you're in there just beating somebody up.
At some point, they become sympathetic to the witness, probably.
I would think so. Yeah, and I remember a judge who has not yet retired, so I will not identify this person, but after one of these trials, because when I was defending cases, I would level the city, you know. And he told me, he said afterwards, he said, you know, that last question you asked that witness, you didn't need to do that. I got your point. And I was like, oh, okay. And then I started thinking about it. I'm like, well, why didn't he want me to? Yeah, it's because you don't need to. You just need to make a point. So yeah, I think lawyers, honestly, if you want my honest opinion, I think lawyers believe that helps them look powerful or strengthen their case, and it just doesn't. It rarely does it.
So is that just a maturation on your part, do you think?
Yeah.
I mean, maybe you believe that might be useful before you really come to terms with what you do.
Yeah, for me, it's not. I think to put a finer point on it, for me in the courtroom, it's not about me. It's about whoever's making the decision, and it's about my client.
Yeah.
Does it feel good to be right and, you know, beat somebody up a little bit if you know, but I'm not in there for me. I'm in there for the person I'm representing, and I'm also there for the jury, and I'm also there for the judge to make sure they make the right decision.
Right.
So me teeing off on a witness doesn't help them do that.
You're leading that judge to a certain decision.
It doesn't help unless it does. You know, in most situations, it doesn't help to tee off on a witness and beat them up real bad unless they are intentionally withholding information you know they have, and you got to get it out. Then that's the only time it really helps.
Interesting.
Yeah, but even then, I don't yell and scream. Not my style.
I would love to see you in court sometime, man. Maybe just as an observer. But it sounds fascinating, and I'll bet you are outstanding.
Well, thank you. I appreciate that. And we'll probably end up doing that at some point.
I would hope so. It'd be great to watch. I find it fascinating. We got to wrap up. We are over our hour, which is amazing, isn't it?
Yeah, that goes fast.
Do you have a favorite law, movie, show, anything like that you really enjoy, or even if it's not realistic, man? Is it
A Few Good Men?
Oh, that's a good one.
That's just, I mean, one of the best.
Have you ever laid "You Can't Handle the Truth" on anybody?
So, I think like jokingly in a deposition, I've done that before.
Oh, that's awesome.
Yeah, but we have the opportunity to have a little bit of fun. I'll tell you one quick story.
Sure,
It's actually about a
please.
safety guy. So one of my friends is going to be deposed, and he's asking me just the basics. What's this, what's that? And I tell him, the court reporter has to write down everything you say. So make sure you're speaking clearly. And he's like, they write down everything you say? And I say, everything. He goes, every syllable. I said, you bet. So he sends me an email a month or two later with a copy of his transcript. And at the end, he said, yabba dabba doo. I called and said, why the fuck did you do that? He's like, because I wanted to see if she'd write
I just
it down.
wanted to say, that's hilarious.
Yep.
That's awesome.
Mm-hmm.
Oh, man, I've really enjoyed it, Justin.
Yeah.
This is Justin High, everybody. High Younes,
High Younes.
Omaha, Nebraska. Fantastic.
Cool. I will see you at Bike with Mike.
I hope so. Yeah, I hope everybody turns out. Great day. If we get great weather, you can't beat it. And you are a cyclist, you mentioned. You're getting out on the gravel.
Yeah, my wife and I ride gravel a lot. We do gravel worlds every year. We usually grab a group of people that want to try it and want to get into it and sort of marshal them through the process of all the way from buying a bike to doing gravel worlds, which, I mean, the minimum distance, I think, is 30, and we usually do the 75.
No kidding.
Oh, it's great. You could easily do it.
Is it all downhill?
Unfortunately, no.
It's interesting about this ride that we will do on the 7th. The ride down is pretty nice. It's it's just a little bit of a roll, but no real steep inclines or declines. Nice ride down to Mineola. The way back is all uphill. Mm-hmm. I don't know how that happens. Maybe 2 margaritas or 3 margaritas.
Right, exactly.
There's a limit, but it changes the ride.
Yep.
And now it's gotten so large that a lot of people send someone to pick them up, after the actual event. They don't ride back.
Oh, sure.
We force ourselves to ride back, but it's not as easy, man. It's been a pleasure, Justin.
Yeah, pleasure.
Thank you very much, man.
Absolutely. Thanks, Doug.
And hopefully we can do it again.
We will.
Thanks, everybody. I hope you have a great weekend. It's almost May. Crazy.
Yeah, I can't believe that happened.
Time is flying. Do you have children?
I have 2 daughters, and I have 2 stepdaughters. So, yeah.
Fantastic.
Yep.
Very good. Anybody that's going to carry on the family business?
Oh, man, I really hope so. I really want that. But at the same time, I'm not going to, force anybody
Push too
to do
hard.
anything. Yeah, if they find it, they do. If they don't, they don't.
Yeah.
So
very good. All right, everybody. Thank you. Have a great weekend, and we'll be back probably in 2 weeks. Take care.